marriage is considered an institution of divinity and completion. This reflects in the various laws enacted to accommodate the diverse religions, cultures, and customs, provided that they are in accordance with the Constitution of India. They are regulated by the state, which runs material benefits exclusive to marriage. People, especially in the 21st century today, endorse the concept of liberalized marriage, where partners solemnize their union according to their own personal choices, not submitting themselves to fixed societal norms, such as of age, procreation, etc. So then, is right to marry a fundamental right in India? Let's go through a series of judgments first. One of the earliest cases which dealt with this issue was Lata Singh versus State of UP, delivered in 2006, concerning an intercaste marriage. The Supreme Court held that since the petitioner was a major, she was entitled to marry whoever she wanted, and that no law bars an intercaste marriage. The judgment, however, applied specifically to the case, and there was no declaration of law as such by the court. But the court expressly recognized the petitioner's right to choose a partner of her choice. The question of choice has been extensively dealt with by a constitution bench of 9 judges in Justice K.S. Puttaswamy versus Union of India. The court unanimously held that the right to privacy is protected as an intrinsic part of the right to life and personal liberty under Article 21. In the majority opinion delivered by Justice D.Y. Chandrachud, the court held that in the Indian context, the fundamental right to privacy would cover 3 aspects. The third being privacy of choice, which protects an individual's autonomy over fundamental personal choices. In Shakti Vahini versus Union of India, also, the Apex Court adhered to this position. It held that consensually choosing life partners is a manifestation of their freedom of choice guaranteed under Articles 19 and 21 of the Constitution. Consequently, in Shafin Jahan versus K.M. Ashokan, also known as the Kerala Hadia case, the court stated that the right to marry the person of one's choice is a fundamental component of Article 21. However, the Apex Court refrained from addressing how these rights would apply in public aspects, like marriage rights. Unlike Article 16 of Universal Declaration of Human Rights, in which India is a signatory, the right to marry is not expressly recognized either as a fundamental or a constitutional right under the Indian Constitution. Though the above-mentioned cases and international covenants imply a fundamental right to marry, this specific question was never answered by the court, and when it finally did, the court reasoned that it is not a constitutionally guaranteed right. Yes, you heard it right. It made a narrow distinction between the right to marry and the right to choose a partner. So all these precedents dealt with the latter, not the former. In the same-sex marriage judgment, Chief Justice of India Dr. D.Y. Chandrachud stated that an institution cannot be elevated to the realm of a fundamental right based on the content accorded to it by law. However, he added that several facets of marital relationship reflect constitutional values. That being said, and the right to marry the person of one's choice, read as a penumbral right inherent within Article 21, is a relief, a ray of hope, not to shun the possibility of right to marry becoming a constitutionally guaranteed fundamental right in the future. Thank you for watching. Please subscribe for more such videos to the Law and Justice Research Foundation. Until then, see you soon.